All right, let's get started.
Can you hear me, Mr. Reader?
Yes, I can hear you.
Okay. We just left off at the final termination. I want to talk about in a little bit more detail some of the reasons for the termination. One of the reasons that you reference in your letter is the delays. Was that a concern for Canterbury Cove during the course of this project?
Yes, multiple points, yes.
Okay, and what was your understanding at Canterbury Cove as to when this project should have been completed?
My understanding was THB was going to finish their work mid-April 2019.
Okay, I'm going to show you what's marked as Exhibit 85. Have you seen this email before?
Yes, I received that email, obviously without the handwritten notations on it. But yes, I remember receiving that email, the typed part.
Okay, and the email's from Mike Boney, correct?
Yes.
And he works with Travis Boney, the owner of THB Construction LLC.
Yes, Mike Boney is Travis's father.
All right, and he specifically is responding to an email you sent on January 18th, correct?
That's right.
And in that email, you specifically say, I've been told by both Mike and Travis I would have all the information requested below earlier this week. These are all items we have been talking about for weeks. I need all of this information immediately. Did I read that right?
Yes, that's correct.
Okay, and in response, he provides a schedule for construction.
That's right.
And it showed that the final out for the project would be April 15th, 2019.
Yes.
Did you understand that to be the completion date?
That's when I understood THB would be complete with their work.
All right. And did you at this time get any indication or comment from THB Construction that this was anything other than their estimated completion date as required under the contract?
No, nothing otherwise. Nothing varying that, correct.
Did THB Construction ever send you a subsequent email or note that said, this is not the completion date, it's another day?
No, nothing like that.
All right. And we already looked at the contract, but the contract has a requirement that if work is not done by the completion date, there's a liquidated damages clause, right?
That's right.
And it's a penalty of 700, or not a penalty, a damage amount of $750 a day for delays.
Right, a sliding scale based on the amount of the contract, and in this case, $750 a day. Yes.
Okay. Did THB Construction, during the course of your work and before you terminated them in June of 2020, ever explain to you what the basis was for the delays on this project?
No, nothing specific. I mean, we would talk periodically about why they weren't working. I mean, on site, talk to them, but no, nothing formal that said this is what held us up at this point. This is what held us up at that point.
Okay, and I'm going to show you the contract again. I want to look at one provision in particular. And if you look, this is Exhibit 3. And if we look at paragraph 9 for the time for completion, there's a provision that contractor shall provide owner a schedule prior to commencing work. They never gave you that prior to commencing work, right?
That's correct.
But they did give you a schedule after commencing work.
Yes.
And then paragraph 9.5 here says the completion date is extended in an amount equal to time lost due to delays beyond the control of the contractor if a claim is made, therefore, and approved by the owner as provided in paragraph 9.4, which approval will not be unreasonably withheld or delayed. Do you see that provision?
Yes.
All right. During the course of your relationship with THB Construction LLC, before your initial termination of them in March of 2020. So between November of 18 to March of 2020, did THB Construction LLC ever request an extension of the time for them to work in writing
No.
to excuse a delay?
No, they did not.
Did you ever receive any documentation from THB Construction that was compliant with paragraph 9.4, which would be a written excuse for extension of the completion date?
No, I don't believe so.
Did you ever receive anything in writing at any point from THB Construction before the termination where they gave you excuses for delays?
I think I had one text message from Travis in 2020 saying it had rained that day. They wouldn't be able to work on that particular day. That was the one and only time that I can recall.
Did they ever provide you a schedule of weather days that would have constituted, rain delays?
Not in compliance with the contract, no.
All right, but did they ever provide anything to you in writing referencing rain delays or other excuses for their delays?
Yes, they did. And believe it was first part of June of 2020.
So the first time they tried to justify their delays was just weeks before you ultimately terminated them?
Yes.
Okay, I'm going to share Plaintiffs Exhibit 60. Have you seen this before?
Yes.
And what is Plaintiffs Exhibit 60?
That was a paper that they presented, that they being Travis and Matthew Kruger with THB presented when we sat down, we being Ted Reeder and I sat down on site at our construction trailer to discuss with them their draw request that ultimately, I think, is the one that ultimately didn't get paid. No, I take it back. It's the last one that did get paid, but that's what they presented to us as explanation of their delays, that we didn't even know we were going to be discussing that day, but that's what they handed us that day.
What exhibit number is this?
Plaintiff 60, Your Honor. Okay, and Plaintiff 60 calculates days lost to delays. They have a category for rain, a category for junction box, a category for franchise work, etc. And they claim that there were only 168 working days between November of 18 and March of 2020, basically, on this document. Is that fair?
That's how I read it, yes.
Okay, and do you agree at all that there were only 168 working days in that period of time?
No.
All right, and then as support for these delays, they attached what appears to be weather information for Rowlett, rainfall data for Rowlett, the city of Rowlett, right?
Yes. That's what they presented it as.
And as far as your understanding is, this is not precipitation measured at the construction site. This is like publicly available data about the city of Rowlett, right?
Correct. Yes.
And that's all they provided to you, correct?
Yes.
Did THB Construction LLC ever provide any backup information for why the junction box delay was a justified delay?
Never. Other than this, we never had any conversation or certainly no documentation of any of this.
Did they ever provide you information backing up or corroborating why franchise work was a delay?
No.
Did they ever provide you backup information or documents corroborating why a movement of a power pole by Encore constituted a delay?
No.
Did they ever provide you backup information for why THB Construction was not responsible for the stop work order?
Never. No.
Did they ever provide you backup information or documents to corroborate why THB Construction was not responsible for a SWIP violation?
No.
What is a SWIP violation?
SWPPP stands for Stormwater Pollution Prevention Plan, and construction sites big and small, are required to have this kind of plan to make sure that the runoff from the site or construction debris or material isn't getting into the water system. And we had a SWIP plan in place from the beginning, and the city of Rowlett had, at one point, the city inspector had said, well, I'm not going to let you do any more work until you get back in compliance with the SWIP, because we'd have either
All right,
weekly or bi-weekly.
Let me interrupt you, Mr. Reader. Let me interrupt you and ask you a question, because I just asked you what the SWIP plan was.
I'm sorry.
Is the SWIP plan a THB construction responsibility or a Canterbury Cove responsibility?
I believe it's a THB responsibility.
All right. And the violation is because there were issues with essentially the maintenance or the good orderly manner of stormwater pollution control on the construction site that THB was responsible for.
Right. And maintaining what was prescribed in the plan, in the written plan.
Okay. Other than this document, as far as you know, there were no other written documents or justifications by THB for their delays.
No, none.
Okay, I'm going to talk a little bit about vendor payments that were an issue during the relationship. Do you recall a problem with THB Construction during the course of your relationship having an issue paying their vendors timely?
Yes.
And
I do remember that.
Do you have a recollection of when that first started?
I believe I started getting notices or communications from some of their suppliers in either March, April, or May, certainly by May of 2019, maybe by March of 2019.
Okay, and why was that a problem for Canterbury Cove?
It was a problem because we were paying them. I think by May of 2019, we had paid at least 4, if not 5 of their pay applications, which that was their pay that they were supposed to be using in part to pay their suppliers. And I was getting notices from those suppliers that essentially they had not been paid by THB and they expected someone to pay them or they would file a lien on the property.
Okay, and did you work to try to resolve those issues so that the project would not be liened up by suppliers?
Yes, I contacted them directly, or I talked to THB, trying to understand what the problem was, why they weren't paying their suppliers. Got a number of excuses about disputes on other jobs. They were using the same suppliers on other projects, and ultimately told them, I don't really care about other jobs. I need to know my job's bills are being paid, and ultimately talked directly to most of these suppliers' accounts receivable department to say, how much are you owed? Why are you owed this? When did you last get payment? But yes, I had to ultimately go handle those directly myself. THB didn't handle it.
And is that usual for an owner to have to negotiate or deal directly with the contractors, laborers, or suppliers?
No, in fact, I was quite reluctant to do it. I did not want to be seen as the primary contractor in this case. In the same sense, I wouldn't be out directing THB's workers and telling them what to do and being their boss on site for the same reason. I contracted with THB to handle that, not to go to handle it directly.
Okay. And did you, in the course of doing that, did you occasionally enter into joint check agreements with suppliers to make sure that they could get paid and would not file liens on your property?
Yes, in some cases, and I think there are at least 3, if not 4 or 5 such joint check agreements. I think I don't know exactly initially who initiated them, whether it was THB or the suppliers, but they were presented to me and we signed them, I think at the request of the suppliers.
All right, I'm going to show you Plaintiffs Exhibit 75. Is this an example of a joint check agreement that you had to enter into?
Yes.
Okay, and this is dated July of 2019 and it's with Ready Cable?
Yes.
And do you recall occasionally having to pay Ready Cable to avoid them having to lien up your property?
Yes, I recall getting multiple notices, certified letters from them pursuant to state law about giving notice to the owner for a subcontractor or supplier to send notices to the owner if they haven't been paid. Got those multiple times. Asked THB why they hadn't paid it. And ultimately this was and either we paid it out of the next draw for THB or had a joint check agreement similar to this one. And we ultimately did execute one for Ready Cable.
Okay. Do you believe that there are amounts that were paid direct to vendors that by Canterbury Cove that you were also billed for on the pay applications?
Yes.
All right. And are you familiar with the supplier Core and Main?
Yes.
What is Core and Main supply?
I haven't dealt with them directly myself in the past, but having a little bit of experience now with THB, they supply a number of construction materials. In this case, particularly, they were supplying primarily the RCP pipe, which is reinforced concrete pipe used for the stormwater lines on this project.
Okay. And did Core and Main file a lien on the property?
Yes.
I'm going to show you what's Plaintiffs Exhibit 2. Is this a copy of the Core and Main lien that was filed on the Canterbury Cove property?
Yes, that's right.
And you can see here they filed a lien on the property in the amount of approximately $40,000.
Yes, that's right.
And this was filed on July 12th, 2019.
That's right.
All right. I'm going to show you Plaintiffs Exhibit 15. Plaintiffs Exhibit 15 is the pay application number 3 dated January 2019, correct?
Yes.
And it shows an amount of $244,581.66 that was paid.
That's right.
All right. And then if you look at, oops, wrong folder. Plaintiffs Exhibit 16, this is the detail sheets for pay application number 3, correct?
It's not screen shared at the moment.
Oh, yep. Sorry. Thank you.
Yes, that's correct.
All right. And you said that Core and Main was providing the reinforced concrete?
Yes, reinforced concrete.
You broke up there. Can you just say that again for the court reporter?
Yeah, I said yes, that they were supplying the reinforced concrete pipe, RCP.
The RCP. So you can see here on this this pay application, there's approximately 24,000 and 42-inch RCP, 36-inch RCP at 109,000, 24 inches of another 46,000, and 18 inches of RCP for about 3,250. All of that is being requested to be paid in January of 2019.
That's right.
And as far as you know, you paid that, right?
Yes.
Okay. And yet in July of 2019, can you see that, the affidavit?
Yes. Right. I can see the affidavit. Yes.
Yeah. There's a 40,000 unpaid amount from Core and Main, which was work done on RCP, correct? Filed against the property.
Yes.
Okay. And then if we look at the detail for pay application 4, which is in March of 2019, you can see there's an additional 24,000 here. Can you see that? I want to make sure I
Yes.
share.
I see it.
An additional 24,000 here, another 5,000, another 2,400, another 3,250, all for the RCP that was supplied by Core and Main, correct?
That's right.
And then over here on the end, it says 100% complete as the estimated completion percentage, right?
That's right.
So as of March of 2019, Canterbury Cove was being told by THB Construction that the storm drainage work was all done, and with the payment of this pay application would be all paid for, correct?
Yes.
In fact, if you look at pay application 4, this is the same on every one of these because they're a form. There's a certification on each one of these forms that certifies that all
Right.
previous progress payments received from the owner on account of the work done have been applied on account to discharge contractors' legitimate obligations incurred in connection with work covered by prior applications, right?
That's right.
And that the title of the work is free and clear of all liens,
Yes,
and that the work is not defective.
correct.
And they certified that on every one of the pay applications.
Yes,
And yet Core and Main filed a $40,000 lien for unpaid amounts in July of 2019.
that's right.
And ultimately, Canterbury Cove had to pay them directly, correct?
Yes, after I argued with them and about when they were going to get it done, yes, we ultimately went and paid it directly.
Okay, and I'm going to show you Plaintiffs Exhibit 53. Page 2 of 53 is a copy of the cashier's check that Canterbury Cove took out to pay Core and Main the $40,077.17, right?
Yes.
Okay. Are there other examples of vendors not being paid besides the Core and Main one?
Yes, several that I can think of, and in particular, Fuquay Inc. In middle of summer of 2020. And then as I found out after filing the suit, they had not paid their surveyor that had a line item on the draw request for surveying, construction staking, surveying on site, that they didn't pay that subcontractor as well. In addition to the certified letters that I got along the way from suppliers saying we hadn't been paid.
Okay. And you believe that those failure to,
Are you going to show that name? The name
sorry?
of the contractor?
oh, I can.
It's Fuquay, Fuquay.
Thank you.
Ultimately, Mr. Reader, did you have to pay off Fuquay to get a lien release?
Yes,
And I'm going to show you what is marked as Plaintiff's Exhibit 110. This is the final waiver and release of the lien for Fuquay, correct?
that's right. Yes.
All right. And you can see for the court reporter right here how to spell it. All right. Do you believe that those failures to pay the vendors and suppliers by THB Construction were a material breach of the contract?
Yes.
And did it contribute to potential delays and complications in the project, as far as you know?
Yes.
All right. I'm going to shift gears and talk about the tree preservation plan. We talked about this a little bit. You heard the opening. There were a number of trees on the property at Canterbury Cove, correct?
That's right.
And if you look at Plaintiff's Exhibit 73,
Correct. Yes, I see it.
this is a site survey that shows the trees that needed to be removed and preserved, correct?
Yes.
All right, and what's your understanding of how this particular document works? Like, what do the X's mean, and what does this crosshatch section mean?
This is based on the tree survey the city of Rowlett required. Our engineer took that tree survey and then marked the trees with X's that are to be removed, and the ones that don't have X's on the left side, which is the west side of the property, were to be preserved and obviously not wiped out. Everything with an X was accounted for, calculated, the number of caliper inches, and a tree landscape plan that would replace those trees that were being removed was submitted and approved by the city. So this was all calculated, a number of caliper inches that were being removed and a number that were being preserved. And the city had a different calculation depending on how many preserved. They wanted to preserve as many as possible. So it was even more significant to the city that they be preserved as many as possible.
Okay. And when you look at this section, like for instance, up here in the upper left-hand corner, there's a significant number of trees with X's that are intermixed with trees that were to be preserved, correct?
That's right.
And then over here in this section, in the crosshatch section that's got the bolded border, those were also all to be preserved, correct?
Yes.
And was it your understanding that this crosshatch section that was bolded is the area that was claimed by the city of Rowlett to be a violation of the ordinance and the tree preservation plan?
Yes. Yeah, that's the area the city determined all the trees in that area had been wiped out in violation of the approved plan.
All right. Did you give a copy of this tree preservation plan to THB Construction?
Yes, I emailed this to Travis at least a week before they started the groundwork. Now, I will give the caveat that it didn't have that boxed area on the left, of course. At that time, those hadn't been taken out. So that hatched area was not marked as such, but the tree preservation plan, yes, was presented to Travis beforehand, and then on site to Mike Boney before, from my hand to his in early November as well.
Okay. And were you relying on THB Construction to properly remove trees according to the plan?
Yes.
And what did THB Construction end up doing?
Within a couple of days of them starting the groundwork, and I was out there to visit, obviously, and at that stage, it was harder to visit since they were, bulldozing all over the property and moving dirt all over. But when I did go out to visit, within a couple of days, saw the trees had been removed, not to where the line of X's is, or essentially that's a north-south boundary of the trees to be removed. They had removed trees down to the left side where that heavy black line is, down to the left side of that hatched area. And I emailed Travis about that within 24 hours of seeing that, asking him if he was aware of it.
And did you get a response?
No, I don't know that I did. I think I spoke to him on the phone about it. I don't think I got an email response from him, at least nothing substantive about it.
Okay. I'm going to show you what's marked as Exhibit 89. Can you see that?
Yes.
And what is Exhibit 89?
That is a copy of the stop work order from the city of Rowlett issued to Canterbury Cove approximately a year later.
Okay. And was this because of the city had discovered that there were trees removed in violation of the plan?
Yes, exclusively because of that. Yes.
And between the time of the removal and the time of the stop work order, THB Construction had done nothing to remediate the issue, correct?
Correct. They had not even mentioned it to the city. And well, right. No, they had not done anything.
Were you relying on THB Construction to remedy the tree issue since it was done in violation of the contract?
Yes, I expected them to talk to the city and work it out, whatever needed to be worked out. Obviously, initially, I didn't know exactly how many trees had been taken out, but I could tell it was more than one or two.
Okay, I'm going to show you the contract, which is Exhibit 3. And it has specific provisions for dealing with trees, correct?
Yes.
If I can get to them. So paragraph 29.4 are the general specifications for this particular job, correct?
That's right.
And if you go down to paragraph 18, subparagraph 18, there's an affirmative obligation on the contractor to protect all the trees unless they're authorized for removal, right?
That's right. Yes.
And were you relying on the tree preservation plan to be Canterbury's authorization for what trees were removed or not removed?
Yes.
And this also gives Canterbury Cove the right to back charge for any tree damage by the contractor, right?
That's right.
And the rate is $150 per caliper inch.
That's correct.
Did you ever calculate what the total caliper inches were of trees removed improperly?
Yes. After that letter from the city, the stop work order you showed earlier, I forget exactly which exhibit it is. Immediately following that, I personally took the tree preservation plan in hand, went on site, climbed around through the trees to count, because each of the trees as part of the tree survey, initial tree survey, had been labeled with a green ribbon, if it was 8 inches caliper or greater, so that the tiny trees weren't tagged, but everything at 8 inches and greater was tagged with a green fluorescent green ribbon and a numerical metal tag sequentially numbering each tree. And there were a few hundred trees, at least I want to say close to 300 trees total that were tagged, most of which were going to be removed. But I went and took the plan and looked and walked through the grounds to see which trees were still standing. And that's when I calculated the number of trees that I determined had been removed.
Okay. And the calculation, the total number based on the $150 per caliper inch led to what amount in back charges that you believe are THB is responsible for?
Roughly $77,000.
Okay.
It's nearly 500 caliper inches, I believe.
Okay. Would it be $78,600?
That sounds about correct. Yes.
All right. And the city of Rowlett charged a penalty to Canterbury Cove?
Yes. The city's figure was a lower number of trees removed, but yes, they assessed a dollar amount, a number of caliper inches and an associated dollar amount based on that.
Okay. And that amount was approximately $45,190 or so?
Yes.
All right. So the net amount owed under the contract to THB Construction for the trees would be the difference between the $150 caliper inch rate and what you've already paid to THB and deducted from their last pay draw.
Right. Yes.
Paid to the city and then deducted from THB's last draw. I should say that correctly.
Yes. Yes. So there's a difference in the per caliper inch price as part of the complicating factor. The city charges less. The city's fine was based on a lower per caliper inch than the contract's amount.
Okay. But the net damages that you contend are still owed based on the contract to Canterbury Cove were approximately $33,000 related to the trees.
Yes, the difference between 78,000 and 45,000 approximately. Yes, sir.
Okay. Now you filed, ultimately you terminated them and had to hire an additional contractor to complete the project work out there at phase one, correct?
Yes.
And did you incur expenses associated with having to finish the work that you otherwise would not have had to incur if THB had done their job?
Yes, there was work that had to be completed and corrected that I expected THB to complete and or correct, which they did not.
Okay. I am going to show you. I'm not going to show you that. Hold on. One of the slides that I used in the opening, because it's a summary of these expenses, try to short circuit some of this.
Mr. McCafferty, can you send me that PowerPoint?
I certainly will. Should I send it to Ms. Pinson?
Yeah, send it to Ms. Pinson and ask her to forward it to me.
Okay. Can you see the slide that says actual mitigation expenses?
I can see it, yes.
Okay. So this is a summary of the exhibits that have been admitted into evidence that have invoices related to these amounts. And I want to briefly ask you about each one of these.
Yes.
There's a provision here for $1,000 related to a payment to Cardinal Strategies for updating the SWIP plan and an inspection. What was that about?
That followed in connection, I guess, with the exhibit you showed earlier that referenced the SWPPP delays that THB was referring to. That was the cost of updating the SWIP plan for the current conditions at that point, which is in early 2020. That was the fee that Cardinal Strategies charged to update that plan and to do an inspection immediately thereafter. So that to approve to say that it was now in compliance with this updated plan and we could go back to work. THB could go back to work.
Okay. And the second line there shows as-built surveying work for approximately $2,814. What is that?
That was the surveying that we hired, CBG surveying out of Dallas to go take the elevations and measurements of the finished work that THB had completed, mainly the paving and the new grading elevations, the lots, the open land, in addition to the paving, to determine if it was built according to the original plans, the original engineered plans, and how it had varied as it was actually built. That was a cost that was in the contract that THB was expected to pay. We ultimately went and paid it because I hired a surveyor to do it and paid them.
Okay, there's a provision here, a line item of $16,575.25 for final grading in phase one. What is that?
That was money we paid
Can't hear
to
you.
mainly Dowager
Hold on, Mr.
utilities
Reader.
and other contractors.
He's cutting out.
That is a 16.
Hold on one second, Mr. Reader. Can you hear me?
My internet. Okay, I can hear you. It says my internet connection is unstable.
All right, give
Is
it a
that
second.
better?
Yeah, it's better now.
Okay.
Yeah.
The final grading was, we had hired Dowager Utilities, a contractor we used on a couple other smaller jobs to finish the grading work around at various parts of the property, mainly along the city public, where connected to the public street, the right-of-way area, along Cheeser Road, the existing city street there, to finish the grade, because the way THB left it would not meet city inspection for a finished look,
Okay.
finished grading.
All right, the 12,812 for corrective paving work. Can you briefly describe what that is?
Yes, they had sections, panels of concrete, of the newly paved concrete, and curbs that were already crumbling or had cracked. And the city required the sections that had to be corrected because they were the water meter valves inset into the concrete were too low or too high, requiring removal and then repaving of sections of the concrete.
Okay, and then there's 3,300 for raising water meter taps. What was that about?
That was another punch item list from the city. That was where each water meter for each of the 61 homes in of phase one would of course have a water meter run to it. There's a black box that has the water line come to it. Those had to be raised so that the city would approve it and be able to set the water meters ultimately.
All right, and then there's a separate one for $3,500 related to required corrective work by the city. Why is that separate? What is it?
That was more of a miscellaneous, smaller items as far as just stuff on site of sealing the concrete cracks, and various smaller things on site that would be, a few $100s a piece. And they're just not broken out here, but they are on the invoice. But things that the city of Rowlett inspector specifically required, but are smaller dollar items.
Okay, there's 1,800 for street cleaning and erosion control. That's pretty self-explanatory, right?
Right. The erosion control was after the long term, once the work is done. Again, that was part of actually that ties in with the first line to update the SWPPP plan. That was part of the work that Travis Boney agreed to do, putting down erosion control matting. And ultimately the THB didn't. We ended up having to do it and pay for it.
Okay, and then there's an amount of 8,516 for a maintenance bond. What is that?
That is the 2-year 20% maintenance bond required by the city of Rowlett and most cities in some version or another, that says that the city's infrastructure, when the city takes it over and is responsible for it, that we as the owner, usually it's the general contractor, which would be THB, will warrant up to 20% of it for the first 2 years. They did not get that maintenance bond. We had to.
Okay. And then that last number there, we've already talked about it. That's the net number of your trees under the contract rate versus what you had to pay the city and have already withheld from THB, correct?
That's the difference number. Yes.
Okay. All right. And there are certain costs that you believe you'll still have to incur because of THB's non-performance related to phase one and phase two, correct?
Yes.
All right. And these are estimated future costs. Why do you have a $5,000 estimated cost for demolition of excess paving?
some of the paving that they did, THB paved beyond where they're supposed to in phase one. So there are sections that we will have to remove based on partly the as-built surveying we did. We just talked about, as well as water lines that are now under paving that shouldn't be, that we're going to have to remove that paving in order to get to those water lines to connect them into phase two. And so this figure is mainly the removal of that and haul off of that excess concrete.
Okay, and then there's a section for 8760 related to recalculation of phase two. What is that?
Again, tying into the as-built, now that because of the elevations of the concrete that they did in phase one, that didn't match up with the original phase one, phase two engineering plans, we've had to engage our engineer to adjust the phase two work to make sure that the phase two concrete, at least the plans, will match up with the existing phase one concrete. Obviously, we can't have concrete that doesn't match up to itself, but with the original plans and the ground work on the ground, they wouldn't match up now. So this is our engineering and surveying work to be ready to do phase two, given the work that they did in phase one.
Okay, and there's a line item for $5,000 related to phase two sanitary work. Now, my understanding is that THB did lay phase two sanitary sewer pipe as part of the work during phase one. Is that right?
That's correct.
Okay, and so what is the charge here related to the phase two sanitary work if it's already been done?
That's our very rough estimate of whether the work has been, that the work that's been done is acceptable, is in good condition. It's been done, in the good workmanlike condition. We don't know exactly what they've done there. It's never been tested or inspected. I believe that the pipe is there, but I honestly can't say that I've seen it firsthand that the sanitary work sewer is even in place, let alone that it's done properly. So that's our very rough estimate of the cost for corrective work.
All right, and does the city require testing of that sanitary sewer work before they will ever issue approval for phase two?
Yes, it has to be both air pressure tested and TV, meaning they run a video camera down the entire line, and it's a multi-day process to do that testing.
All right. The last line item is $10,000 for a cut and fill on site in phase two. What is that?
That's our estimate of how much it will cost to move the dirt around on phase two, on the phase two land. We have that was part of that cut and fill on phase two was part of the original excavation on the contract with THB. One of the first lines, one of the first categories in there. This is the additional work that will be needed in phase two based on what the current status is on phase one.
Mr. Mahafity,
Yep.
Cafferty, I'm sorry. You have a number of numbers listed on all of these different line items. If you could provide, and the other side is welcome also to do this as well. But if you could provide, you're going to send me the PowerPoint, but also those pages with exhibit numbers associated with them. It'd be, assuming we're going into tomorrow, if you get those to me by tomorrow morning, that would be great as well.
No problem. Happy to do it.
All right. What else are you?
I actually am almost done, Your Honor, but I have a couple of little things to tie up. I'm going to show you, Mr. Reader, the affidavit of lien that was filed by THB in this case. Have you seen, this is Plaintiffs Exhibit 1. Have you seen this document?
Yes.
Okay. And this is the affidavit claiming a lien, correct?
That's right.
And if you look at the attachment to the affidavit, Exhibit A, it's the itemized line item for how they get to how THB gets to the $370,000 lien amount, correct?
That's right.
And this was filed in
July
of 2020, correct?
Yes.
All right. The first line item is what they call the 11th draw. So this is the draw that for the final amount of work, and they have a line item of $77,470. Do you see that?
Yes.
All right. And then they attach a pay application for pay application number 11.
That's correct.
Right. And then they attach the detail for pay application 11.
Correct.
All right, and here you can see, this is the column where they have amounts for this estimate right here. You
Yes.
see the first charge is a $3,000 charge for a finished cut for after paving.
Yes.
See that?
Finished cut lots after paving. Yes.
All right, and do you dispute that that charge needs to be paid?
No, I don't dispute that. That's one of the legitimate charges.
Okay. And there's a charge for $5,400 related to wheelchair ramps.
Yes, that I hardly dispute. The three of those four, if you note, the column to the left has four wheelchair ramps. Three of those are in phase two, are part of that concrete that we were talking about a minute ago that will have to be removed.
Mhm.
And then the fourth one was not on a plan, it was never on any plans. They put it in the southwest corner, southwest corner of the development. And I remember talking to Travis saying, why did you put this here? It doesn't belong here. It's not on any set of plans, and yet we're being charged for it.
Okay. So you dispute the $5,400.
Yes.
All right. There's a line for 4455 in dead end barricades. Do you dispute that?
In a trivial way, yes, it's 98 lineal feet because they're 14-foot long panels. There's 7 of them, 98 lineal feet rather than 99. It's $45 difference, but otherwise it's acceptable, yes.
All right. There's a charge for $21,273.78 for maintenance bonds. You dispute that, right?
Yes, it was
In
never.
fact, you listened to Mr. Hayes's opening statement where they're withdrawing that amount now, right?
Yes,
But it's on the July lien,
correct.
and they've not filed an amended lien.
No,
All right. And then the last two charges on here are a 3,500 6-inch 3,500 PSI concrete of 14,450. You see that?
yes,
Do you dispute that charge?
yes.
Why?
That is the phase two concrete that, again, I say phase two, meaning it's beyond the line of our engineers designed for phase one concrete paving and splitting it into 2 phases, had a line showing where the concrete was to go to. THB went beyond that in an arbitrary fashion at different points. And this was the area that we calculated was beyond that phase line essentially. And so we had this discussion actually with the draw number 10 and had deducted it from that. And now it's reappeared here in this 11. But no, our feeling is that should not have been done. Some of it's going to have to be removed. If it is acceptable, it'll be paid in phase two, is what we told them over a year ago.
Okay. And then the last line here is 37,500 for removing on-site dirt. You see that?
Yes.
And do you dispute that amount?
Yes. Yes, that is soil. The column to the left shows 7,500 cubic yards that they moved. That was, again, dirt that should never have had to be moved in the first place, but it's our position that was, even if it was dirt that needed to be moved on site, how they came up with 7,500, I don't know, but ultimately that should have been included with the grading that's on the one of the first lines of this of their contract amount. The grading on site should include that.
Okay. And almost done. Go back to.
And both of those are on CO number 4, which we never had an executed change order number 4.
Okay. And if you go back to the exhibit A to the affidavit lien item, the next lien item is draw number 12, the retainage. You dispute the retainage amounts because if you adjust down draw 11, that necessarily means the 10% withholding would go down as well, correct?
That's right.
So this amount is improperly overstated by at least that amount, correct?
Yes.
And you also believe that you have offset rights with respect to the delays and other expenses that you've had to retain that would further reduce this amount under the contract, correct?
Yes.
And then there's a line item for the tree removal penalty, which they re-invoiced to you, correct?
Yes.
Did they accept payment for draw 10 that when you deducted it from draw 10?
Yes,
So they took your payment for draw 10 after you had told them you were deducting it, but now this is being re-invoiced to you.
yes. In fact, I personally talked to Travis on site when I handed him the check and said, here's what we're deducting, and he accepted it.
Okay. And then phase two, 51,000 in a retainage amounts, you dispute those amounts because they're just not due yet because phase two hasn't been completed or approved, right?
That's right. Yes,
And there's potentially going to be offsets specifically related to potential corrective work and testing work that needs to be done for even that work.
that's right.
Okay. So as a result, essentially of the $370,000 that they filed as a lien in July of 2020, according to Canterbury Cove, the best that they could hope to argue is actually due is approximately $3,000 in draw 11.
Yes, that's about it.
But if you
Slightly
take
more.
into account all of the damages and excess expenses plus delay damages, they end up owing Canterbury Cove a significant amount of money, correct?
Absolutely. Yes.
All right. And did you have to retain attorneys to prosecute this case and vindicate your contractual rights?
Yes.
All right. And have you incurred legal fees and expenses associated with this litigation?
Yes.
All right.
Substantial.
Yeah. In your honor, I would note that the parties of, at least with respect to Canterbury Cove's legal fees, have agreed as to the reasonableness and necessariness of the fees, and we filed a stipulation to that effect last night. So I would just ask your honor to take judicial notice of that.
What is the stipulation?
The stipulation, oh, I don't have it in front of me, is that the amount of fees and expenses, you know what, I have to read it to you. We specify that the fees are both reasonable and necessary, and the amount of the fees, but I don't remember the exact dollar amount. I'm sorry, your honor. I can email to you the stipulation separately with the PowerPoint as soon as I get done here.
Good.
And with that, your honor, I'll pass the witness.
Any cross?
You're on mute, Scott.
Yes, Your Honor. Mr. Reader,
Yes.
there is no completion date, a specific completion date included in the Master Contract Exhibit 3 for Phase 1, correct?
I believe that's correct. Yes.
And at the time that was signed, written in a date, you could have proposed a date, you could have done something as part of the master contract to have a specific completion date, correct?
You're asking if I could have done that? I don't think I could have inserted a date unilaterally. No.
Well, you were the attorney on behalf of Canterbury that was negotiating this particular contract, correct?
I was not acting as an attorney in this case. No. At that stage, no. I was contracting as the owner.
Okay, but you reviewed the contract at that particular time, correct?
Yes.
Okay, and you could have, as an attorney, seen this doesn't have a completion date, correct?
Yes.
And you could have pointed that out to THB and suggested or said, we need a completion date in this particular agreement, don't we?
I could have said that, I suppose. My problem would be it's a project supplement is what was referred to, meaning it would be separate in addition to the contract. It would be a separate writing, as I understood.
Objection, non-responsive. At that particular time, before you signed the master contract, sir, you could have said this needs to have a specific completion date included, correct?
I could have said that, yes.
And there is not a project supplement for this particular contract, correct?
There's not a document titled project supplement. That's correct.
Okay. And in fact, even we can look at Exhibit 94. Oh, I'm sorry. We're pulling that up, Your Honor.
I only see an email or someone's email account.
Yeah, we're,
What exhibit number is this?
this is exhibit number 94. So this is a letter that you wrote in March 2020, where you acknowledge that there is no formal project supplement or work schedule ever provided, correct?
That's correct. So it says there.
Okay. Going back to, let's go to exhibit 3. And first page on paragraph D. There is, in fact, a reference underlined in D to a project supplement, correct?
Yes.
And in paragraph E, on the 5th line, Roman numeral 2, it again refers to capital P project, capital S supplement, correct?
Yes. Specific to such project.
Okay, and let's go to the second page. In 1.1.3, as part of contract documents, there is again a reference to a capital P project, capital S supplement, correct?
There's a reference to it, yes. But the context is,
Objection,
reading its
non-responsive.
context.
You could just limit your answers to my question, please. And the next paragraph starts, an enumeration of the contract documents governing the work to be performed on a specific project shall be set forth in the project supplement, correct?
Yes, it says that there.
If we could go to exhibit number 5. And this particular document sets out a description of the work and quantities, correct?
Yes.
And looking on the third page, there is an amount of 1,668,966.28. In fact, that was the contract price, correct?
Hang on. Yes. For phase 1, yes.
Okay. Would you consider exhibit number 5 to be a project supplement?
No.
Okay.
Does exhibit 5 have a completion date on it? I didn't, it was kind of, you went through it kind of quickly.
Yeah, let me just, I'll ask that question. Sir, there is no completion date in exhibit number 5, is there?
No.
And the amount that's contained on page 3 of the 1.668 million, which you say is the contract amount, that was prepared prior to the signing of the contract, correct?
You're saying this dollar amount was prepared prior to the signing? Yes.
Yes. Mhm. So prior to the signing of the contract, at that point, you or Canterbury Cove knew the amount that it was contracted to pay to THB, correct?
Right. This was a budget figure. Yes, that's right.
Go back to exhibit 3. In fact, let's go to Article 9, which is on THB 011. Okay, we're getting there. Okay. The first line in that, owner shall give contractor written notice to proceed, and contractor shall complete the work in the number of working days specified in the project supplement. Did I read that correctly?
Yes,
And your testimony a few minutes ago is there was not a project supplement, correct?
there's not a project supplement.
Okay.
No, sir.
So in fact, the completion in the number of working days specified in the project supplement, without a project supplement, there is not a specific working days, correct?
I'm sorry, repeat that question. You lost me.
Okay. As there is this, as there's not a project supplement, which is to define and set out the working days, then there are not a specific number of working days included in this contract, correct?
I disagree.
Okay, let's go to exhibit. Well, you don't agree. You're not disputing the fact, again, that there is not a project supplement, correct?
I agree there's not a formal project supplement. I said there was not a document titled project supplement. That's correct.
Let's go to 9.4. First sentence there reads, the completion date for the work to be performed pursuant to a project supplement, as it may be amended by change orders, in parentheses, the quote, completion date, close quote, underlined. So the completion date is based upon then the to be set out in a project supplement, correct?
Yes, I think that's what that sentence says. Yes.
Okay. And let's go to 9.6. And 9.6 sets out various damages for failure to complete on time. The third sentence starts out, for each calendar date that any work shall remain uncompleted after the completion date specified in the project supplement. We've established that there is not a project supplement with a completion date, correct?
No. We've established that there is not a document titled project supplement.
So is your contention or the Canterbury's contention that this email from Mr. Boney several months after the contract then is a project supplement?
It provides part of the information required that the contractor was obligated to produce as part of a formal project supplement. It provided one part of that information. So it is not a complete project supplement, but it is part of the information required by the project supplement and required by the contract to be provided by the contractor.
And you're then just pulling out of the air of what then a project supplement could be?
I have no idea what a formal project supplement should look like or should include exactly, or as far as the form goes, because there is no explanation of what a project supplement is. It's not a defined term. It could be 10 pages long. It could be 2 pages long. I've never seen a form saying this is what will go into the project supplement, but through the course of the contract, it specifies the contractor will provide this information, among other things, that includes completion date.
And you agree that, let's go to Article 2. 2.2, contractor shall prepare and submit after instructions from owner to commence an estimated progress schedule for constructing the improvements to be approved by the construction manager and owner. And it's common in construction projects that a progress schedule is provided, correct?
Yes, it's common.
Okay. And nowhere in 2.2 says the estimated progress schedule is a supplement, a project supplement, correct?
That's correct.
And you will have as well conversations with contractors as, hey, how's it going? You know, what are your projections to finish, correct?
Sure. Yes, we'll have conversations like that. It's not uncommon.
But you don't take such conversations then to mean that is now a completion date, that if there is a provision for liquidated damages, I can enforce that against a contractor, correct?
A verbal conversation like that? A written, yes. A verbal, probably not, because I wouldn't be able to enforce it, but it's certainly meaningful. The way you're describing it, it would be irrelevant. I mean, why even have that conversation if I don't think it means anything?
Well, it helps the owner in seeing what type of work is going to be next, when things may or may not be done, correct?
Right. Yes.
2.2 then
Yes.
does not define the estimated progress schedule in any way to be a capital C completion, capital D date, correct?
That's correct.
And there is nothing else other than the email from Mr. Boney several months after the start of the project that you would contend would be a project supplement that relates to a completion date, correct?
No, that's it. That's the document I relied on.
So if that email from Mr. Boney then is not a project supplement that identifies as an agreement the completion date, then Canterbury's contentions for liquidated damages under Article 9 would fail, correct?
I think you're asking a legal conclusion. I can't answer that.
Well, let me go another way. Then the completion date under your analysis from Mr. Boney's email, that establishes a completion date. There are no other documents that you are pointing to that would establish a completion date, correct?
Correct. That's right.
And 9.6 that we looked at previously, the liquidated damages is for work that is not, it remains uncompleted after a completion date. So if no completion date, there are no liquidated damages, correct?
Again, that sounds like a legal conclusion to me. I can't answer that.
Okay. And there was some testimony previously about written notices of delay in the work by THB. Under this contract, as you read it, if there in fact are not liquidation damages because of no completion date, there is no requirement for any written notice of delays that THB may be encountering, correct?
I don't think so. That's a lot of contingencies there. I can't agree with that.
Okay.
It's a lot of speculation.
Has
I think-
phase one, okay,
Go ahead, I'm sorry.
has phase one been completed?
It has not been accepted by the city. The work has been physically completed. Yes, I believe so.
And at the time that THB was terminated, the only remaining work you would categorize as punch list type work, correct?
No, that's not correct. Punch list was included, but there was other work that had to be done.
Okay, let's go to Exhibit 98. And in the second paragraph of 98, the last sentence starts with the punch list. So in that particular email, you're referring to punch list items, correct?
Yes, there was punch list items that we had discussed, meaning Canterbury Cove and THB. And that's what is referenced there, yes.
And punch list items or punch list is typically in the construction industry, the final items to complete the work by the contractor, correct?
Generally, or there are things that need to be corrected. Generally, I think of a punch list as erroneous things or things needing fixing. If there's still work to be done, you could have a punch list before all the work is complete with the understanding, well, you still have to do this other stuff, but we have, these things, these 5 items need to be fixed or whatever. But I'm trying to think back. I think this punch list was inclusive of both of those. I'd have to look at the punch list again to remember.
Okay, and you can look at Exhibit 99. We'll pull up 99.
There we go. Mhm.
And this is your document up at the top. Let's move it up to the top. That you refer to the punch list for THB, is that correct?
Yes, that was the punch list between THB and Canterbury Cove. And I say that to distinguish it from what the city then required when they did their inspection. They had their own punch lists.
Okay, let's go back to Exhibit 98 on the second page. And go to the bottom. A little bit up. And in number 4, that's in the center of the page, at the end of that, and you referenced the current retainage amount of $177,066.97. Is that correct?
I see that, yes.
And that's an amount that you're referring to on work that has been done and paid for, and the 10% retainage holdback has been made, correct?
I believe so, yes. As opposed to the grand total, yes, that's right.
Correct. And under the contract, if there are not then chargebacks or other expenses, then that money is to be paid to THB?
I'm sorry, repeat the question.
Sure.
I can't hear you.
Okay, under the agreement, unless there are chargebacks or other expenses, then at the completion of the project, then the retainage amount is to be paid to the contractor?
If they comply with the requirements of the contract for retainage, yes. There's a provision in the contract referring to final payment. Yes. With certain conditions to be met.
Going back to the completion of phase one. So was your testimony the city has not yet approved phase one as being complete?
That's right. They have not accepted phase one.
Okay.
And it's not yet city property.
What do you understand then the holdup on that to be?
Primarily this lien, the lien, the THB file.
Okay. But the work under the agreement with THB has been fully completed, correct?
As of today, yes. But it wasn't completed by THB. I'm not sure if that's what you're saying.
No, I'm just asking, has the work been fully completed?
Yes.
And when was that work approximately fully completed?
The work, well, I'm hesitating only because there's the work that was THB's responsibility versus the things that were going to come later, like landscaping. The work that THB was to be completing was finished around the end of October, 1st of November of last year. And then there were,
right, after THB's work was completed and there were other types of work like landscaping that was not a THB item, correct?
right, correct, that's right.
There was some work performed by THB on what we've referred to as phase two, correct?
Yes.
Okay. And that work by THB on phase two was then agreed to by Canterbury, correct?
The work to be done was, yeah, I guess part of the complicating factor here is the grading and the clearing was for the whole property. That wasn't split into two phases. So that was all done as part of the original contract, of course. Secondly, the other aspect of that is the sanitary sewer, if that's what you're referring to in phase two. Yes, they did the sanitary sewer, installed the sanitary sewer lines in phase two with our agreement, yes.
As part of the removal of the trees, Canterbury did not put up anything around the trees like a rope, a cord, or otherwise as to the protected trees, correct?
Well, we hired THB to put up silt fence that went around the trees, including those that were to be protected. Did I personally on behalf of Canterbury Cove? Certainly not, no. It never occurred to me to do that.
Okay, and you said I want to make clear that Canterbury itself did not put up any fences or otherwise around the trees that were to be protected, correct?
That's right, no.
Okay. You had referred to some liens and notices from workers, subcontractors on the phase one project, contending that they had not been paid. Are all of those contractors, workers, then been paid?
So you're cutting out, have they all been paid to date currently?
Yes.
Yes, they have all been paid.
And any liens that may have been filed by subcontractors have been satisfied and the liens removed and released, correct?
Yes.
You had gone, near the end of your testimony, had gone through some potential future costs to be incurred by Canterbury. At this point in time, all of those amounts were just speculation, correct?
With the exception of the engineering work, I think it was 8,700, something like that. But yes, the round number dollar amounts are estimates, yes.
Okay. And there'd been no documents provided as to those estimates, correct?
I don't believe so. As I said, they're based on somewhat on speculation of what's been done or what will need to be done.
And Judge Hoffman had inquired when you were going over a list of some of the cost amounts as to whether there were any documents provided that are part of the exhibits as to those numbers. As to some of those, there are not documents that have been included in the exhibits today, correct?
I'm sorry, so there was the last part that there have not been documents.
As to some of the categories that were identified on the document showed on the screen, there are not documents that are part of these exhibits here today, correct?
I believe that's correct. Yeah, as far as the estimated figures, that's correct. Yes.
Okay. And meaning that Canterbury doesn't have any documents to support those estimates, correct?
Well, we don't have third-party contractors. We have our calculations that we've done ourselves. I mean, it's a matter of handwritten. I could run through how we came up with those estimates and what we base that on, but that's not a quote. No, there are no quotes to that effect. Those are our in-house estimates of those costs that we figured ourselves.
You had referenced also as it relates to the tree removal issue, there being a city number as well as a number that you or Canterbury calculated.
That's right.
And the Canterbury number was substantially larger than the city number, correct?
That's right.
And there's not you don't have a document or some way that you calculated the $77,000 amount, correct?
Yes, I have my figures. I don't know off the top of my head if it's a document of the 137, but I can tell you it was 524 caliper inches times $150 per caliper inch. I think I counted 48 trees that had been removed.
But you don't have a document that you went out and you've marked where those were removed or how you got to that number, other than just today, your memory, it was so-and-so number.
I have a document, the sheet that I took out with me. I don't know. That's why I say off the top of my head, I don't know if that's one of the exhibits here. I know there was such a document that I may have gotten to my attorney late in the game here, but I don't know if it's one of the exhibits or not. But it's a 2 foot by 3 foot copy of the tree preservation plan that I personally marked as I walked through it. So to answer your question, I don't know if it's an exhibit. I do have a document I would refer to if you wanted me to identify the trees that I identified as those 48 trees.
You had testified regarding a charge by THB for dirt removal of $37,100. Is that correct?
That's correct.
And that dirt was excess dirt that remained on the property after THB did its grading pursuant to the engineering plans, correct?
It was excess dirt that was on the property. Canterbury, or THB did not do its grading according to the engineered plans though.
But in any event, the dirt at some point was going to be required to be moved from the property, correct?
Yes, it was going to have to be moved wherever it came from. I don't know precisely where it came from. It was piled up on the area where the trees were removed.
And in fact, that dirt then was hauled off by THB or its contractors, correct?
Yes,
And you were aware that that dirt was being hauled off, correct?
yes. I have no idea how much dirt was hauled off. It was a lot of dirt.
Because you were out there, what, almost every day during this project?
Around that time, I was there, yes, every day.
And you had gotten into discussions in March and then thereafter of 2020. There was an effect of startings of COVID that affected that work in May of 2020, correct?
Not that I know of. That's the first I've heard of that. If that was an issue for THB, but was never discussed.
I'll pass the witness.
Any redirect?
You know what, Your Honor, I'm going to do something real quick here. Can I get the screen share back? Oh, there we go. Perfect. Mr. Reader, I'm going to show you a slide that we looked at previously, but I've modified it here and then, because Judge Hoffman asked for annotations related to exhibits. I've also emailed this, Your Honor, to you as well as to Mr. Hayes.
Okay.
This is the summary slide of the actual expenses, correct?
Yes,
All right. And then if I've annotated it with the exhibits over here. So if, for instance, the cardinal strategies for $1,000, that is discussed with the invoice that appears at exhibit 68, correct? And I'll show you exhibit 68 so you can see it. Can you see it? Let me try that again. Can you see that, Mr.? Uh-oh, we lost Mr. Reader. Can you hear me, Your Honor?
I can.
All
Can you
right,
hear me?
I can hear you, yeah, but Mr. Reader's screen just went black. Hold on one second. Can you hear me, Mr. Reader? Uh-oh, I think he just got disconnected. Well, I'm almost done, Your Honor. Do you want to see if we can get him connected? Or do you want to take a break right now and then I can try to get him back?
Yeah, that's fine. We can go ahead and take our lunch break, I guess. Let's go ahead and reconvene, let's say at 1:10.
Okay, great. Thank you, Your Honor.
Thank you, guys.